Firstly, sir, thank you so much for taking time to speaking with the Supreme Court Observer. We just have a few questions, especially in light of the LAWASIA Conference 2023, that is the 36th LAWASIA Conference, and the upcoming Constitution Day. So firstly, there is a variety of discussions that we expect in the next few days. All of them in one way or another are rooted in the core question of access to justice. How can people access fair and reliable justice? What do you think, sir, are some of the challenges in access to justice in society today?
So, I believe that one of our strengths is compared to many other countries, despite the judicial system being slow as it is perceived, in terms of footprints for the National Legal Service Authority, which I head. I think we are helping people in many ways to access justice. Let's understand the basic. The basic is that first, the existence of benefits which are available under existing law is a challenge. For example, women. We have changed law, but changing the approach of society takes time. And some of them are unaware. So awareness is one important factor. Then comes enforcement of the rights. We endeavor to see that matters can even be sorted out without going to court, because at a village level or district level, there are perceptions of what the law is, how men perceive it, especially in family law matters. And that's the friction on issues of monetary aspect, because real estate is involved in that, land is involved. Even helping the socially and economically less advantaged sections of the society by trying to help them with small things. It may be a ration card, it may be other aspects. So what I can tell you is there are paralegals. These paralegals are spread out, and I call them our army which helps out. So there is a huge change in access to justice concept. It's how you look at access to justice. Access to justice includes trying to resolve matters. Access to justice includes taking the matters to court in every footprint of the matter. It also makes helping people in terms of reforms to see that implementation of bail orders takes place. For example, we found at one stage in Nalsa that there were about more than 5,000 cases where bail had been granted and people had not been released. Now today we are evolving a system, we are a technological system whereby all the stakeholders work together, and we've been able to tackle this whereby if bail is granted, within 7 days information will flow if the person is released. So somebody will go and find out why it is happening. The only thing is in terms of volumes, we have a large volume as compared to most nations. And I think what has to be looked at is that why is so much of litigation in the country? When I've looked at this issue, I had an opportunity to go to do a study of this, go through an exchange program of Justice Department. Say in California, huge amount of litigation, but 97% plus gets settled. In our system, litigation doesn't settle. We only now got the Mediation Act in force, and I'm a great votary of mediation. I feel in times to come, we must use mediation, because no system in the world, I repeat it, no system in the world can deal with the volume we deal with. And linked to this is the government's approach. Because more than 50% litigation in India, the government or a public body or a public authority, the party. Therefore, they must have a more pragmatic approach to it. Unfortunately, I feel nobody wants to take responsibility. Everything is thrown into the lap of the court. That's another challenge. So we are improving in access to justice, but we must reduce the pipeline by taking cases out of the legal system into alternative dispute resolution mechanisms. And also, I believe that in family matters, even business matters, mediated settlement is better than an adjudicated settlement, because sometimes we give them what they may not want because we are constrained by law. But on the other hand, in a mediation, they are able to get possibly better what they want, because the mediator has a leeway to decide how it is done.
You mentioned the use of technology in ensuring that bail orders go through. You see technology as a sort of cornerstone, perhaps, in access to justice going forward.
Absolutely. You see, the positive of what happened in COVID, it accelerated technology. You today have judicial proceedings being taken to the people. People are hearing constitution-based matters. People on YouTube are hearing other proceedings.
With hundreds and thousands
And
of
a lot of people talk to me. I see you. It's not important that they see you. They get a feel of what is happening in the courts. Otherwise, it was some kind of an unknown quantity, and they did not know what the challenges are. Technology, certainly, digitization is taking place. Virtual hearings are taking place. We've been talking about benches and other issues of courts. I think with technology being introduced, we have actually, I've seen some of the states where I've been, district level or even high court lawyers appearing directly in the Supreme Court through the virtual system. It was cost element saving, it was a confidence level saving because the local lawyer will know something about it. So I think a huge change is taking place. And the government is also in this area very supportive. They are willing to spend the money and give money for digitization, for computerization, for having e-courts. And I think that's the way forward. And the session I'm sharing with other judges is dealing actually with the issue of the challenges of technology and what was resolved in Bangalore so many years ago. So the dynamics have changed because when technology comes in, those dynamics will change as to what can be.
But the fundamentals remain the same.
Fundamentals remain the same. To my mind, the fundamental is very simple. Judge has to do his job honestly. I think that's the bottom line. And he should be willing to work hard enough and have some element of common sense and knowledge of law. Broadly, I think these three things are what are relevant in my perspective.
You talk about judges' work being central to this, and I think that applies largely to the legal profession as well. Arguably, lawyers and members of the legal profession have the most amount of influence on society, on shaping the law. In terms of immediacy, what do you think are the next steps that this community should take forward in ensuring an equitable society?
Let's split it into two parts. The lawyers have a role to play, but the legal profession is very inequitable in a way. We have a very bottom-heavy system. Middle is largely absent, and some people top is good. So top I include not the absolute top, but so what is happening is the work circulates amongst an X number of lawyers. That breeds its own problem. And solutions possibly lie in opportunities to younger lawyers to work with seniors. Now, national law schools all over the country are getting placements, but there are many other law schools. National law school graduates, how many of them will go and work at district level? So you need people who are equipped to handle matters at district level also. The education of lawyers, the education of law as a subject is needing reforms. That's some part of the government which I would support. We've encouraged the bar council to strengthen the bar council. Because the number of law schools as such is very difficult to get quality without judging them at the entry point. We have far many more lawyers than the system needs. That's another thing. Of course, lawyers can go to, law graduates can go to the litigating field, to corporate side, many other areas. Some of the younger lawyers are going to teaching, a very encouraging fact. There's some stage of time we didn't encourage teachers. So we have complete paucity of teaching staff in most law schools. Where I've been chancellor, it's a challenge to recruit people to come and teach. So the younger elements still are willing in some of the law schools where the economic opportunities are better.
There seems to be a trend of growing authoritarianism and shifting of powers and arguably a weakening of democracy across the world. Many argue that this means that the executive is becoming stronger with a certain degree of untrammeled power. Is there a threat then to an independent, robust judiciary?
See, there has always been a little turf war which goes on. So there's a turf war in the sense that when legislative is strong, they try to push it. When legislative and executives are weak, the judiciary is pushed strong. The balance lies somewhere in between. Executive often doesn't understand that it's our job to do a check and balance. So I've had informal meetings. The executive come up and say some of them key. आप हमसे नाराज हैं, आप agree with us. Tell them there's nothing known as anger or being anti. It's my job. It's my job to check you in it. Everybody would like unchecked powers, and therefore when judiciary checks that power, this problem arises. India, it's been always a little bit of tussle. Appointment process itself is a tussle. The executive feels, well, they passed almost unanimously a law which was struck down, and that's a fact. Which my answer is, many laws are struck down, many laws are upheld. You may bring another law, but till a law remains, it must be implemented. It's not that if the views of the government are not listened to. Having been part of the collegium for very long, government inputs comes, Chief Justice comes, IB report comes, we do independent verification, and then clear. If you see the list clear, not even 50% of the from starting point to the end point they get. I believe the government should take a more liberal view of these things. I can understand somebody feels though that a nominee has a very strong political links. That has always been a question mark. But I think small issues, when you occupy the position of the judge, you learn to shed, for purpose of judicial education, your clothes. Look at this Krishna here. Undoubtedly a leftist who came here and celebrated that. Nobody objected to his political inclinations. So the question is, the man is important. Who is that one who's coming? He's in a position to shed his perspectives. Because nobody is, in that sense, apolitical. Everybody will have a political inclination. Certainly in India, everybody wants to talk about politics and talk about politics. That's always there. But in the judicial work, to be able to keep that aside and do so, I believe over a period of time that we are trained for that. And we do keep those things apart. And that's the reason sometimes the same guy will give a verdict which the government may not accept it, the same guy will give another verdict which the opposition finds it difficult to accept. The reason is that in his best judgment he is trying to do what he feels is right.
You brought up the collegium and the importance that it has. And often the collegium is spoken in the same breath as diversity is, and the fact that the court should look like the people that it seeks to protect. What are our challenges in ensuring proper diversity, in ensuring representation in our courts, not just the Supreme Court but lower courts as well?
So diversity, if you see, there are many aspects of diversity. One aspect is regional diversity. Always happens. But sometimes in a particular court, there may not be a person whom we perceive is fit to come to the Supreme Court. So you wait till somebody is eligible. It's not necessary that in every court at a particular stage of time there will be by seniority somebody who is brought up. If you ignore seniority, you go a little down, you can't go drastically down because of the dynamics of the issue. Second is women representation, which is often talked. See, I always tell them, look, then women should have joined the legal profession in very large numbers earlier. The dynamics did not happen. Today, the recruitment processes, invariably more than 50% are women at the district level. They are happening in places like Bihar, I went there, and many other places. In Delhi, the last selection I did 10 years back, it was 73% women. So it's not paucity of women there. One, of course, as a profession as such, it takes time. It's more difficult, certainly, as in any other field for a woman to establish. I accept that. So at the district levels, the promotion levels, they will come eligible to High Court after a certain number of years. Today, if the recruitment on average is more than 50% women, about 36% women even now exist in this subordinate judiciary. Now, for elevation of High Court from the bar, somebody should be eligible who has joined the profession at that particular stage. So when you say, oh, you're not giving representation, that's not there. We look to it. We sometimes lower the benchmarks to see that we can get diversity. I have been in Chandigarh, I have been in Chennai, Delhi. I think we keep recommending a fairly large number of women. Sometimes we find that in the particular age profile, we are looking to 45 to 55. 45 has to be an exceptional cases. 45 to 48 would be somebody with a long tenure but is exceptional. So there's an age restriction profile within which selection takes place. Therefore, it's not fair. Sometimes lawyers say, oh, if there are so many in district court, why not in the High Court? It's not in the High Court because there are not enough women lawyers in that age profile. That's the problem. Third is representation community-wise. They are there, but even again, if the benchmarks are kept more considerate, it's difficult at times to get from some community at a particular stage of time. People, it's not that they are not available. So I presided over Chennai, which has a particular orientation towards community and caste. I endeavored to pick up the best from that subsector sector. So there it goes, sect, subsect, sub-subsect. You try to work it out in that way. Delhi, nobody bothers in Delhi. Which part of the country you come from, which community you belong to. So it depends on the dynamics of the place. What is the history, what is the accepted social norms from which it comes. Yes, certainly more people are involved, but availability in the relevant age of a relevant caliber at least is required. I think as things will pass, it will happen. Let's look at services. So when the reservation for OBC was made, they were less. As time has gone by, a lot of them in some places are performing even better than the general category candidates. So it's a process of time. There's no wonder want to be waived, which will happen on a one.
In 2 days, on the 26th of November, on Sunday, we'll be celebrating Constitution Day. Do you have a message for our viewers?
I'm speaking on a particular aspect, and I don't want to speak here on that aspect. I'm introducing on the law day. But I would say, broadly, it's constitutionalism which needs to be preserved, which is all stakeholders must realize that the Constitution provides a particular manner. It is the prime document, and therefore all law will be tested on the Constitution benchmark. Maybe better preparation of law sometimes are necessity, because the problem we face at times in hurriedly brought law creates its own dynamics till the creases are ironed out. I believe legislative drafting is a very important part of it.
Just a quick last question. In light of the session here that we can expect in the next few days, what are you looking forward to, sir, with the LAWASIA Conference?
So LAWASIA is debating many aspects. I'm of course a part of the session. I've been part of the session because I have next 3 days of conferences. We are having a law day on 26th, 27th, 28th. We have the International LAWASIA Conference for the first time, where participants are coming from especially Africa and Southeast Asia, which is what they look to in supportive systems. There is also the technological conference held on 29th, which I am opening up, which talks about use of technology. So if you see what LAWASIA is talking about, they're talking about the growing need of technology, the growing use of technology, how to control technology. All three are important. But I do believe I was just doing something. See, the human species is most important. A judge works with both his mind and heart. You can't work within parameters. There will always be a little bit of discussion. There will always be a heart element. No machine, no system can get that human element. So humans must operate technology. And having the right humans operate the technology is important.
Thank you so much, sir, for your time. And we look forward to hearing you speak as well, hearing you moderate the session. Thank you.
Thank you.